Good morning, everyone. I hope you are doing well this morning. Good to see you all. Let me go ahead and tap into Ada Court. So we are ready. We are here to listen to, wrong one. We are here to listen to Brian Koberger today during his hearing to determine if he is going to indeed change his plea to guilty, which is what we are hearing. So good to see you this morning. I hope you have your coffee. Hope you got some sleep. Hi, Cece. Hi, Wheezy Girl. Hi, Mini Panthers. Hey, Town Chat. Good to see you. Hi, Whispering Winds. Hi, Gypsy. Good to see you all. We're going to see what goes on. I'm just got it tapped into Ada County. It is supposed to start in about 29 minutes. So I just thought I'd bring us in here early. So what this hearing is about, for those who are not aware, is Brian Koberger back in November of 2022 was accused of and is today allegedly going to be pleading guilty to the 4 unalivings of 4 Idaho students, University of Idaho students, Xana Kernodle, Ethan Chapin, Kaylee Gun. I always have a hard time with her last name, Kaylee Goncalves, and Megan Mogan. They lost their lives, and he is accused of coming in with a KINIFE and slaying. One of the most gruesome scenes many have seen, to where there was red, stuff, fluid, dripping through the front of the home. So just terrifying. The families imagine the shock, you send your children to college and they don't come home. Ethan was one of 3. He was a triplet, and his other 2 siblings also attended University of Idaho. I believe they still do. What I think is going to happen today, Cece, or I hope, is he's going to remember when he put his plea forth of not guilty. He did not speak it. They spoke it for him. So today we are hoping the judge will make him speak his plea, or even talk about why, a little bit. So it depends on what the judge determines. The judge could ask him just to say guilty, not guilty. He could require him to provide some sort of a input and explanation to the change of plea. So we are not sure what will happen, but Judge Hippler is fabulous. It's not Judge Hippler, excuse me. I'm sorry, I'm still on the other, is it? I'm still on the other case, forgive me. Let me pause for 1 second and verify, because I just thought it was. Let me make sure. Yes, it is. Okay, I was thinking, did I just say Vallows judge? So Judge Hippler will make that determination today. Also, what has occurred recently is, because of the Dateline leaks, and I will let you know, we'll talk about that in a second. Because of the Dateline leaks, the defense had filed another motion for delay of trial. Now, this trial was supposed to be in Moscow, Idaho, and because it was so high profile, the defense requested a change of venue to Boise, Ada County. And that is indeed, by the way, where Lori Daybell and Chad Daybell were both convicted. So they are in Ada County, which is in Boise, and it has been delayed and delayed and delayed. The home in which the slaying occurred was torn down already. The University of Idaho felt very strongly. They went forth. They had support by some family members, not all, and it did indeed go down. 3D model had been made for, purposes of the trial. But to me, that was evidence that's, priceless and precious, in my opinion. I don't know how many of you feel. They said it was just such a terrible reminder, as people walked by it. So needless to say, the families had to raise money, GoFundMes, to get to Boise, to stay in Boise, take off work, all of the above. And this has gone on for 3 years. And this has gone on for 3 years. And now they have to hurry because June 30th, a motion was filed saying they were going to have this today, and he was going to allegedly plead guilty in exchange for serving his entire life in prison. No parole, no appeals. And he, as most of you know, he was a doctorate student at the time he was arrested and charged in criminology. He's got that brain so he'll have nothing but time, education, and an iPad to help him research loopholes. So I hope they have a very ironclad agreement in place, because laws change, right? We are 30 years, 35 years down the road since the Menendez brothers were convicted. And they were at a point where they were not allowed to, there was nothing left for them to do. No more appeals, no more parole. They weren't allowed to have parole. And here they are very possibly close to getting out because laws have changed. So laws could change. And I hope that's not the case, because these families are pretty much being told they are being told he will spend his life in prison. He just won't have the death penalty. And in Idaho, the death penalty was passed after Koberger was arrested and before Chad Daybell was convicted and is on death row for the death penalty. They have brought back the firing squad. So Koberger has saved his life from the firing squad. Let me hit live stream just so we have it on. Let's see what they got. Okay, now he has saved his life from the firing squad, and we went through a little plea. Minnie, I'll check. I think if the prosecutor started with the plea deal instead of all these delays, the family would have been this upset. Well, yes, but remember, they were one person who was very pivotal in not wanting Brian to accept a plea deal and go to prison for the rest of his life was his mother. Now, she wanted a trial. She wanted the opportunity for him to be found not guilty. And there were people who thought that was a really bad call. Let him take the plea and save his life. At least you can visit him. And so, because it wasn't looking good at that point as far as Dateline had the leaks. But, there were things in there that I didn't know, but a lot of what we knew, and they should know, the defense knew. They just said they wanted to prepare now that they knew the jury knew. So the judge did give them on June 30th a 1-week delay. Not years, not months, 1 week. I love Judge Hitler. He's great. And they had asked again on June 26th, they brought back up, filed a motion they want to bring in the alternate perpetrator theory. Well, not only that, I read the motion to you all the other day. They weren't just trying to bring in one theory, they were one perpetrator, but 4. I had no idea. 4 alternate perpetrators. The judge denied it, stating that, well, I can read it to you. Let me read it to you. There it is. Okay. And welcome in if you're coming in. We are waiting for Brian Koberger's hearing. 1 second, Minnie. I'm checking. We are waiting for Brian Koberger's hearing. I was just going to pull something up and I forgot what I was pulling up. So he will be avoiding the death penalty. Oh, by the way, there is a verdict in for Diddy, I'm hearing. So This is the motion for them to bring in 4 alternate perpetrators and why the judge isn't having it. Okay, and I can just read you some of the highlights because I don't want us to miss the beginning. Okay, so this is the state of Idaho versus Bryan redacted order on defendant's offer of proof regarding alternate perpetrators, filed June 26th. And if you were with me in the video the other day, or the video, I'm sorry if you're hearing this again, but I do want to just bring this forth because I believe this was something that altered his decision to go ahead and take the plea, in my opinion. Because this right here, bringing in alternate perpetrators, is a use of trying to get reasonable doubt from the jury. So if he had brought in 4 alternate perpetrators, there could have been a chance one juror that would have formed reasonable doubt for one juror, and we would have had a hung jury or something, right? So the state previously moved in limine, seeking to preclude defendant from offering or arguing alternative perpetrator evidence. The state doesn't want it without first satisfying the applicable evidentiary standards in accordance with the court's subsequent order on the motion, because they brought it back up. The court concludes at this time, defendant's alternate perpetrator proffer is inadmissible under Meester. It is irrelevant and or excluded by I.R.E.403. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. So, one thing I do want to tell you that they came up with is the seminal Idaho case on the admissibility of alternate perpetrator evidence is Meester. A defendant wishing to present such evidence at trial had to first present proof of connection with the crime. Such a train of facts or circumstances as tend clearly to point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. Okay, and so what they are saying is that if the defendant proffers evidence which merely tends to mislead the jury, meaning there's no real connection, but they're just trying to mislead the jury to, toss some reasonable doubt in there, that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable than it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions. A defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. Here, the defendant has offered purporting to establish the 4 individuals as alternate perpetrators objectively fails to meet the Meester standard. Namely, the evidence is entirely irrelevant. And don't forget, we just found out in the last, days that the DoorDash driver is actual eyewitness to Bryan Kohberger allegedly being there. So that was probably a big gut wrench too that they had to deal with, right? So it says that nothing links these 4 individuals to the homicides or otherwise gives risk to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. 3 of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. To protect the defendant's they're explaining that lived within walking distance, because they redacted the rest, lived within walking distance. Sorry, I have to plug in my computer, y'all. Sorry, gotta plug in the computer. Hold on. Okay. Y'all doing okay? Oh, yes, Minnie. I did see that. And yeah, I'm sorry I didn't respond. I was on the phone researching. P. Diddy not guilty? Are you kidding me? Holy cow. Thank you for letting us know. All I need is Jesus. I just told everyone that verdict was in. Off topic breaking news. P. Diddy not guilty on 3 of 5 charges, expected to be released on bail today. Wow. There is no justice anymore. Trafficking. Wow. We wonder why our children are disappearing and people are being sold, in my opinion. Wow. Teresa says, I heard the 2 counts Diddy was found guilty of, he could get up to 20 years. Oh, okay. Well, that's good, right? We all know he won't, but he's not going to get time served, from what I heard one of the attorneys say. Well, at least he's not going to get time served. Thank you for that update. All I need is Jesus and Teresa Williams. And that's very disappointing, isn't it, Randa? We're just waiting for Ada courts. And I was just reading to you the motion of the perpetrators, the very last thing. We have a couple more minutes. I'll finish it and then I'll come back over. So some of the perpetrators lived within walking distance of the crime scene and were familiar. Oh, we already said that. With the layout of the victim's home prior social events. These are the perpetrators. Koberger was trying to get admitted, but the judge said, no way. So did the state. There's no relevance. They're not connected. They happen to just be in walking distance of the crime scene or at social events that they were at, but no connection saying they would have anything to do with it. While perhaps this evidence could suggest an opportunity to commit the crime from being at the victim's home for prior social events, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there's no compelling evidence that any of them had a motive to kill the victims, unalive, much less physically harm them or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. So their DNA didn't even match. So that's for the 3 of the 4. The 4th individual did not even know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out of the exit of the store. That might be that stalker, remember, that we heard about, while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample, and with the other alleged alternate perpetrators' lab reports excluded his DNA from samples taken from the crime scene and victims, and there is no evidence connecting him to the crime scene. So therefore, that was not allowed to be admissible. So they had a DoorDash eyewitness. Dateline leaked all this information that was out there against Koberger. So they wanted a delay to prepare for a jury that would know some of this stuff ahead of time. The judge only gave them 1 week and then denied their 4 alternate perpetrators motion that they filed on June 26th again. So that might be why we have a plea, that he realized, he better save his life, because jury selection was to begin July 30th. And the trial was to begin August 11th. I'm going to mute you for a second while I go grab some coffee. I shall be right back. Welcome in. Hit that thumbs up. Thank you, my friends. What'd y'all think about the news last night regarding the ransom? Were you all shocked? Okay, I am back. So yes, Minnie, I read your text from last night. That that KP buttered 2 rolls, right? For herself. Is that what it was? Hi, Gypsy. Hi, Sandra Marshall. Sandra, are you talking BK? What about the video with the 2 shadows the night his crime? I'm not sure about that. Is that about for BK? Interesting. That's an I did not know about that, Sandra. I haven't deep dived every detail. I've just been following it since it happened, but that's interesting. Cece. Oh, that's what I wanted to tell you. Cece said that ransom demand would have had me biting my fingernails off. We were pacing, we were nervous, we trauma bonded, and you're going to meet her tonight. The actual lady, Mindy, who received the ransom demand is going to come on tonight, 8 p.m. Eastern, to share her story from beginning to end of receiving this contact, him trying to find her and contact her whole story. So don't miss tonight. I think it's really nice of her to come on because, you know, that's involvement in something that most people don't ever want to be involved in. So very nice. She's going to be on tonight. I've almost got the thumbnail ready to go. And Minnie says, yes, she took 2 buttered rolls. Minnie, you were hot last night when you saw that. And I am so sorry I didn't respond. I was on researching already with another individual on something that we were checking out. And I am so sorry I didn't respond. But Minnie saw KP on the Texas Roadhouse footage took 2 buttered rolls for herself, and when Sebastian reached for the one in the basket, she said something and he pulled his hands back in shrinks. I will be checking that out. Thank you for noticing that. The pacing and the nervousness is no joke. They were able to jail a person behind Sebastian and lie on the stand. Yes. Yes. She's talking about BHB. They jailed BHB. They were actually, the DA puts forth things to the grand jury to get BHB indicted, but yet can't muster up anything for child A, BUSE, misleading law enforcement, none of the above, nothing for Sebastian. Karen, that is what she is going to talk about. That's what she's going to share with you, some of what she's going to share. They reached her through a relative, ironically. So she's going to share her story, and I'm so grateful. I'm so grateful she responded instead of ignored it, because what would most of us think? Oh, scammer. But you cannot think that, right? You just can't think that, because what if it isn't? And that was the whole problem with not getting a response from law enforcement, Sumner County, is honestly, she and I keep talking about it. What would we have done? What would we have done for 1 week, for days, whatever? Knowing that someone was trying to offer a ransom for our dear Sebastian, saying he's alive, we're going to have him call, all of the above, and I do believe he's alive, by the way. And we couldn't get, still haven't. Remember, you heard the update last night. I think they still haven't responded. Craddock hasn't. But anyway, what would we have done? I don't know who else I would have called. I don't know what else I could have done. What would, what could you do if Seth hadn't hired this other team that jumped on it? Y'all, I just don't know what we would have done. I honestly, that bothers me so much, because I just don't know. We would have been sitting there for 7 days thinking, this is Sebastian's life and no one will answer. Well, I mean, I would have had to start calling police stations. I would have started calling police stations all around Sumner County, like Hendersonville, all of the ones around, just to get someone to call them if we didn't have at night. That's all I could think of that we could do. Let's get on to, let me go click this. Jay, in my opinion, ever since CP made that statement about not owning a funeral home, he said we're not millionaires. If we were, we wouldn't need help finding Sebastian. First thought was ransom. Hey, all I need is Jesus. That's a great connection. If you can find that statement, will you send us the link? Thank you, my friend. That's a great statement. That was early on, right? That's interesting. Yes, yes, yes. I am telling you. Let me click this and make sure they're not streaming for us. No, okay. I'm not sure if they're going to put us on a 30-minute delay like the courts usually do. This is, I don't believe they would, because we're not dealing with juries, but we'll see. Hi, Shirley. How you doing? Shirley says, I'm sure if it was a true ransom, Sebastian's army would have found a way to get that money to bring Sebastian home. Right. But I agree with you, Shirley. We would have raised it, right? But here's the deal. We wouldn't have had any law enforcement to interact with the individual. That's, what are we going to do? Put money into a crypto account? We couldn't have. We needed someone to be there to get Sebastian, to hear his voice, to prove it was him. And none of that was going on, other than for, of course, at night. They had people on boots on the ground, people on airplanes. They were within hours ready to put the whole reward out. Oh, thank you. Thank you so much. Oh, I appreciate that. Web sleuths. Okay. Yes, I know. And Prayer Warrior, I'm so sorry, you all. I know we're working on so much, but John, I apologize. This is what I've been doing this week. This is why some of the things I hadn't. Jonathan Hong's family has a ring cam video that appears to be him. Yes. And Snohomish County sheriffs won't do a thing. Mainstream local news are stepping up and helping. Okay. And we were doing Devlin and him today and Sebastian, and with everything popping and going on, Jonathan's going to be tomorrow. Devlin is going to be sometime this week. I am waiting for confirmation. So thank you for sharing that, though. Yeah, they've given them a real hard time, and they went straight up to the FBI, who told them to report them to the Attorney General. Local law enforcement report them, and they did. The Attorney General's office of Washington gave them an attorney on it. They have the National Autism Association working with them to fight the claims from law enforcement that are inaccurate, and to try and get resources. So that one's been a mess too. The one thing we need to tell people, yes, Gypsy, it is very sad. I hope we can find Devlin too. You're right, Prayer Warrior. They aren't doing their job. That was just what's coming out of my mouth. That's the thing. Why are parents of missing children having to beg law enforcement to help them? This is becoming, I'm not going to say common, but we're seeing it happen, and we should never see it happen. It happened in Buckeye, Arizona, to Daniel Robinson's father. It happened to Seth Rogers in Tennessee. It happened to Summer's case, but she didn't have a voice that screamed, "We want help." Sebastian had Seth. Jonathan has his dad and sister and family. But it's just not right, and we're not going to tolerate it. I don't know why they're not doing their job. But if we have to get to where we have marshals, or we have federal people who just handle missing kids cases and skip these little towns, then we need to start doing something. Because these little town sheriffs who don't intend to look, can't look, whatever's going on, whatever it is. I'm not accusing, I'm just giving some speculations. They should not be in the initial days of an investigation of a missing child because they lose too much evidence, overlook it, turn away, don't get there. My opinion. I don't think missing children should go to the local people in some states. Tennessee, absolutely being one of them. Makes me sick, in my opinion. I can tell you 100% honestly, I still do not have a response. Not that I deserve one from Craddock or Craddock. I got one from Carter because I demanded it. But I still have nothing from Eric Craddock. And now you think about this. We have a sheriff who sees a ransom demand coming across his desk for a very high-profile teen in the town that's his town to serve and protect. He has not once told the public. Oh my gosh, that's what I was going to tell you. He hasn't addressed the public on this at all. He hasn't come forth. He's done nothing, not even tried to interact about it. But here's what I was going to tell you. Last night when I got off, many of you were texting me or emailing me that the locals were really scared. And I don't blame them. They've been scared this whole time, but quiet. They didn't know what to do because they didn't know nothing was being done. But now they see this. We've been trying to tell them. I agree, Jules Kelly. He's on his way out, in my opinion, too. 100%. I agree. I cannot see anyone wearing a badge sitting in a chair who can't even answer a ransom demand for one of his only high-profile case. And I agree. I agree, Jules. It's gone to, yep, I agree. Now there's going to be, in my opinion, a federal investigation. In my opinion, I don't know about all this stuff, but we read the update. Oh, wait, we need to get on here. Hold on. Okay. Let me refresh just in case. Let me make sure. Hold on, y'all. I just want to make sure I'm not missing it while I talk. Sorry, you all. I'll be right there. I'm just checking things. I don't want us to miss anything.
I remember some people cheered.
Okay. Okay, hold on. They've got something here now. I want to just get here. It says, okay, here we go. There we are. That's what I was looking for. Make sure I didn't pause it. Okay. So we're ready to go when it goes, okay? Yes, thank you, Minnie. I clicked it and you are amazing. I want to say something to my mods. I am so grateful for the things you all do. For me, for the channel, for the chat, for Sebastian, for the children. This week, the things you have sent to me, the things you're working on. I mean, I'm not even asking at some of it. You're bringing it all forth. And it's a lot, and it's good research. And I really, and some of you are hanging flyers and all these things. So I just want to thank you, and not just my mods, but my mods have really this past week helped me out so much. And now you know what I've been going through this past week. So I truly appreciate you all. And I appreciate the check-ins. I appreciate the what can I do to help? Is there any topic you need research today? I appreciate all of that. And your confidence when I ask you to research something that you don't share it with anyone else. And I appreciate that. Thank you, Karen. They are excellent mods. They are excellent mods. And I truly appreciate you all. So Thank you. So anyway, I agree with you. I think that yes, the confidence is crucial. It really is. And I appreciate you all for that. Like if I say, go research Brian Koberger on this topic, you all bring me what you find. You don't go circulating it to 13 other content creators. And I appreciate that. There's a reason when I ask you, there's a reason I'm asking you. For instance, you can see from this past week, it's relevant when I ask. So I appreciate you all very much. Yes. Yes, Shirley. Kidnapping becomes a federal crime if it's transported across state out of the country. And they mentioned Mexico, so it became federal and it was ignored, allegedly. Well, it was. I was there. I mean, I was going through the whole thing. But she will be on tonight at 8 p.m. at Eastern Time. I do have a team. Thank you so much. As a matter of fact, every mod who is in here right now, would you please email me? It could be blank, but what I need in the subject line is just all capital letters mod. I have to shut down one of our apps that we use as mods. Remember I told you I was, breached a little bit a couple weeks ago. So I need to shut it down, open it back up. But I need all of you, if you would, just put mod in, email me at crimetimebuzz@gmail.com, and just put mod in all caps. Thank you so much. Yes, they are the dream team. They are the dream team, for sure. And we have a waiting list, Hey, Jen. Jen, will you do me a favor and email me today in the subject line, all caps mod? Thank you. I'm just trying to get some things put together for all of us. So if you are modding and you are in here, and we do have a waiting list, now. That's pretty cool. We have a waiting list for mods now. So you all are doing a wonderful job. I appreciate all of you. I truly do. Don't miss live tonight, 8 p.m. Eastern, with our friend who received the ransom request. You know what, you all? I want to tell you something. I can tell you a little bit. I'm going to do unplugged. Our unplug's off today because of this, but I'll come in with an unplug tomorrow where we can really talk a little bit about some things that really went down. Obviously I can't tell you things I can't tell you. Oh, you sent another new case. Bless you, whispering. Where are they from? And I hate it. Are they vulnerable? Tell me what happened. When did they miss? I'll read it all. These poor kids. These poor kids. Thank you, you all. That's all I want is that. And then I'm going to respond to you with a few things that I need. So hit the thumbs up, please. Oh, 14 in Wisconsin. Okay. What part of Wisconsin? Because I have a lot of relatives out there that can help. Oh, Jen, I'm sure that are you starting some for your trauma with the loss, my friend? Grafton. Okay, I'll have to check. Okay, hold on. Oh, you are so sweet, Karen. Karen says, Power says, I think respectable people attract great mods. Buzz is so good about the way she presents. Oh, I'm honored. Okay. Yes. So I will tell you, since you are all, I'm glad to hear people asking about Devlin. Devlin Tate from Michigan. He has cerebral palsy, other medical conditions, and he is missing. They believe he may have been trying to travel to Yuma, Arizona to see his mother. Okay. So I am working on, and this is going to happen, a family member coming on our channel, okay, of Devlin's. So that's what we're working on right now. Jay, when you say you will be on at 12:30, do you mean Mountain Time? If I say 12:30, wait, now, when did I say 12:30? Like 9:30? Yes, I meant Eastern Time, my dear. So if I say 12:30 to you all, that's Eastern Time. because I'm 3 hours behind a lot of you. Yes, another child with special needs. And I'm so glad other people have been sharing. I'm so glad his story is getting out there. We do have someone in our community who is an advocate for the family, Panda Bear's mom. And we are going to, so I will be talking with a family member of Devon's and bringing them on our channel. So sub up if you haven't, thumbs up, notification bells, because we need to find Devlin. We need to find Jonathan, and there's a sighting of Jonathan on a Ring camera. Hi, Darlene. So we just want everything to keep moving for all the kids. All the kids. We're going to, in Summer Wells, they are asking for federal intervention based on the fact that no one acted on the ransom demand from law enforcement. So they are asking for federal intervention for Summer also, Summer Wells. I love that YouTube adjusts the time for us per hour. Yes. So when I put out a thumbnail, like I'm about to put out the one for tonight for our guest who received the ransom, it will, for me, I will schedule it at 5 p.m. But for those of you on Eastern time, it will show 8 p.m. Okay, off subject. Did you get kitty pic I texted? Let me check. Prayer Warrior, I am going to do an entire show on Devlin. I am. I have it all ready. I just want to communicate with the family, let them know my presentation of it, ask them any questions, ask them anything else they would like me to bring forth. Okay. So we are definitely going to, I think that'll be really, really good. I really do. I think the more exposure we can give to the more children and keep focusing on Sebastian. Yes, YouTuber. At Night has requested the federal intervention to include Summer Wells as well. So they are looking into Summer Wells. Yes, they have been for a while. Summer's included in some of the reward money. Summer's on the billboards. They have been looking into Summer's case. Yes. That's why they have her on the billboards. That's why they included her on the reward. Now they have included her on the demand for, or request or demand, however they put it, for federal intervention based on inaction from law enforcement. And they included Summer Wells and her, from where she's from. So that is fabulous. They are amazing. And like I told you yesterday, what is going on with the courts? Oh, I bet they have us. Let me just make sure. I bet they have us on the 30-minute delay. So they probably started and do have us on tonight at 8 p.m. Eastern. Yes, the woman who received the ransom demand. And the person tracked her down, which is really weird. So it's just a whole, oh my gosh, yes. I'm muting. I'll address your question, Wheezy, after, but the answer is yes. Look at him. Sorry, I had to get that in there. Last time you'll see him in anything other than a suit, orange jumper.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms.
Kelly.
Allen is here as well,
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to
It's the family, some of them, I bet.
make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism
Wow.
and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right.
I hope he
Ms.
makes it speak.
Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still.
Good.
I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Oh, that's sad the families weren't there.
Yes.
All right, and Mr. Koberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously, there have been a number of motions filed to suppress evidence in this case.
He just said he was guilty.
Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, You did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
Wow.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Um, And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Wow.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Koberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Koberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Koberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Koberger's name, Brian Koberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Koberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before
you
it
hear?
started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town.
Dateline showed that a little bit of him tearing out of
The
there.
evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Koberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Koberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Koberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Koberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Koberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Koberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Koberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until
I'll explain that, you all.
sentencing, which time it would be withdrawn in order to give the
That's the
parties
gag order.
space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm
I was going to Boise.
sure
for
that
a
the
couple
jury
of days
commissioner
for
will
the
get
trial.
word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it.
I wanna
With
watch
that,
him
we're
go.
adjourned. All right, please.
Oh, I wanted to see him go. So you all, Brian Koberger has pled guilty. You heard him. It was very powerful, in my opinion, to hear him admit guilt to each murder out loud. I mean, each red rum, excuse me, out loud, right? That was shocking. So, what did you all think? That was just shocking to hear him actually admit that he went into the home in the early hours and unalived them all. And some of you had some good comments I wanted to talk about. The plea feels like a slap in the face for the families. Yes. Maddie Mogan's dad said he was glad to get it behind them. But yes, I am, Shirley. It's been accepted. He cannot, it's fixed. So he cannot alter it, amend it, ask for a lighter sentence, ask for a change of sentence, ask for an appeal or parole, as long as the laws don't change. Look at the Menendez. They had no parole and now they're about to get out. And quite frankly, I don't know. That one, it's hard to go on those, right? Yes, the DP is off the table, which is why he made this agreement to save his life. And by the way, I did a video earlier this week going from death row to serving a life sentence allows him, if he was on death row, his meals would be served to him through a slot. Now that he's not going to be on death row, he will be able to eat with others. Okay. If he's on death row, he gets a couple. Let me pull it up for y'all. Hold on one second. Let me just pull it up. I'll be right there because I do want to show you the difference. He saved his life, but it's also a very different life. Hi, Panda Bears, Mom. It's also, hi, Bliss, a very different life. Yeah, he said 10 years minimum for each one, but he said he is going to impose the maximum and it's going to be fixed. So hold on one second. Let me get what I want to get for you. Okay. Let me share this. And then before we go, I just want you to know what it meant and what it means for his life in there. Okay. Okay. Those who favor life imprisonment without parole over capital punishment do so in large part because of conditions under which prisoners live on death row. So he would have been on death row if he had gotten the DP. That's no longer on the table. That's why he made the plea. And for other reasons, in my opinion, those 4 alternate perps that the judge will not let them admit. And also the judge gave them only a 1-week delay and other very damning evidence. So he saved his life. So he would have been on D row, but now he will be living in as someone serving a life sentence. So listen to the differences of his life now. Knowing him, he'll be, because of his degrees, helping people with law and stuff. But D row inmates live in solitary confinement in a small cell. So he will not be in solitary confinement unless, of course, during punishment. Those are 8 by 10 feet, small bathroom, and they sleep on a steel bed or a concrete slab. Their cells contain a steel toilet, sink, and a small writing desk. Okay, they receive little. So I'm assuming he will not be sleeping on a concrete slab or a steel bed. Okay. They receive little, if any, human contact. So he will be allowed human contact. His meals will not be served through a door like they are in D row. In D row, they remain in isolation for 22 to 24 hours a day. So he will not be in isolation for 22 to 24 hours a day. Excuse me. Some have exercise time outdoors a few times a week. So he will have exercise time outdoors more than a few times a week. And he will not be in the small cage-like enclosure that D row inmates are. D row inmates have severely restricted visitation rights, so BK will not have those severely restricted visitation rights. See how his life changes in there? When visiting with family or friends, D row, they have to stay behind a plexiglass wall, so he will not be behind a plexiglass wall when visiting family or friends. And prisoners are also in D, the D ones, are in leg and arm restraints during visits, so he will not be going through that. And D row inmates, they're not granted privileges for good behavior, so he will be granted privileges for good behavior. Ew, I don't like that. But anyway, let's keep going. Okay. So he will have more privileges. His housing arrangement will be better. He'll be in a double cell. His recreation and social interaction will be not as limited. He doesn't have to eat alone in his cell. He will get to eat in communal areas. Wow, right? And don't forget, he gets that iPad. That's coming up. He will get access now, which he wouldn't have before, to programs and services. He will have work opportunities he would not have had because they are restricted for D row inmates. But life without P inmates have a wider range of assignments. Okay. It's strict. Visiting policies are stricter for D row compared to the potential for contact visits and more frequent visits for life without parole inmates. So he has a lot of privileges now and a lot of access to privileges, or maybe earning them. I don't know. But he will also have a free tablet, which taxpayers pay for, and where he can purchase a subscription-based entertainment and other services through IC Solutions contract with Via Path Technologies. Okay. Yeah, I have a feeling, he already has women writing him. I'm looking at your comments. Excuse me if you're in the bushes or on replay. I'm sorry that I was just looking into the comments. So he has the free tablet. They do have to purchase their own subscriptions for music and things. My goodness. Via Path Technologies. Prior to the current system, inmates used JPay tablets, which were also not iPads, but allowed similar access to communication and internet entertainment. And now they use the Bridge 8 because it's more secure. Because in the past there were incidents where inmates exploited, of course, vulnerabilities in the JPay system to gain unauthorized access and credits. So the transition to the new Bridge 8 tablet system aims to provide more secure and controlled environment for inmate access to technology. And I'm sure he will be doing a lot of research looking for a loophole. I don't know. I appreciate you all being here. Wow, that was just so powerful to hear him actually, when the judge was saying, and you admit to walking in, sneaking in there and unaliving this person by knife and stabbing, and him saying guilty. I do. That was very powerful. Very powerful, because usually they go down fighting, right, in a trial, and they demand their innocence all the way up into the verdict. Very seldom do we get to hear the defendant out loud like that admit to the crimes. Because even when they're convicted, usually they're heading right to an appeal. Many sit in prison for decades and decades and decades and demand they are innocent. So it was very powerful to hear someone verbally admit in court, to the public, to the families, to everyone. How hard that must have been for all the families. Oh, prayers up for them, thoughts out, good vibes. That was just heartbreaking. Yes, Town Chat, they think the motive was he had possibly an obsession with one of the girls, and that they kind of blew him off, and that upset him because he would never really be one of them, like them, the popular good-looking kids. So, popular good-looking group. But I'm sure now you heard that the judge is holding the gag order in place until sentencing, at which time he said he will withdraw it unless for some reason, he changes that later. But so we will be hearing a lot on July 23rd is the sentencing, all the victim impact statements. That's going to be heartbreaking. Bring your tissues because we're going to be streaming it here and watching it together. And then it's really going to be devastating. It really, really is. So then the gag order will be listed in Town Chat. Then I believe we will start hearing more about motive and who he was in contact with. Jules, there always seems to be a leak, right? Look at the leak in Sebastian's case. We've been leaked many things. Flashlight video was one that wasn't leaked to me. That was Nick Barris had that, but we've been leaked many things. So this is one of the biggest cases. So, and it was a trial everyone was anticipating. So I have a feeling you'll see some crime scene photos. Not that that's wonderful for the families, right? But I have a feeling those will be leaked. At least one, I would guess. So very sad. Sad for the victims. And let's take this day to remember them, because it's been almost 3 years and he is demanded he was innocent, wasn't there, 4 alternate perpetrators. Now imagine, he wanted to bring forth 4 alternate perpetrators and try and say they were responsible for the crime. And now he stands before the court and verbalizes he crept into that home and unalived and slayed all 4 of them. So unbelievable that he would want to bring forth individuals. And that's what they are allowed to do, right? To bring reasonable doubt. When Gannon's crime scene was leaked, the creator got sued and banned from YouTube. Do you guys recall when Maddie Mogan, one of the police officers, posted her body lifeless and then claimed he didn't mean to, send that to his personal things? But I recall he was reprimanded too. I don't recall to what level. It is awful it took so long, Kaz, if he was going to actually, if it was going to get to this, but he had every right, to file. They were smart to file all those motions if they were going to go to trial, because the length of time they were thinking would take away the sting of the crimes, which it didn't, and let the community heal a little bit before he went up, but they hadn't. And the victims' families hadn't. And sadly, I'm not sure if all of you knew this, but this firing squad, he just dodged the firing squad. I wonder if they would have, well, I shouldn't say that. But ironically, he is now going to be living a better life than he would have on the D row. You heard of all the privileges he's going to have now. Oh, and did I forget to mention they will accommodate his vegan diet. So he will have his vegan diet in the courthouse in Idaho, or in the prisons in Idaho. They will accommodate vegetarian, kosher, vegan, and any other nutritional and diet needs that are submitted and probably proven, whatever. But yes, he will get his vegan diet. He will get his exercise now that he will be around people. If they don't get him, yes, he did dodge a literal bullet, the firing squad bullet. You are right. Well said, woman's warrior. He will be around people now, and if they don't get him for what he's done, I have a feeling he will be like, Mr. Legal, trying to help them all and position himself that way because of his education. But I don't think they're going to like him, in my opinion. I don't. And no, we will never forget the kids, the Idaho 4, whose lives ended. And now he gets to still live. And I'm very sorry for the families, and to the families of Xana Kernodle, Ethan Chapin, Kaylee Goncalves, and Maddie Mogan. We here at Crime Time Buzz, if you hear this, send our deepest vibes, prayers, thoughts to all of you, that your healing can begin. If this wasn't the answer you were looking for, that you get through this and move forward the best of your abilities, and remember that they will always forever be in the hearts of the world, never forgotten. So, amen. Remember, hug your loved ones today. Honestly, I almost lost. Manny was found, Jane. What does that mean? Whispering. Tell me Manny. I'm sorry, whispering. It's not registering with me. Can you clarify? Yes, he admitted publicly. I mean, that was really powerful. Really, really powerful. Oh my gosh. Okay. Got it. It just clicked with me. I'm sorry, you all. I'm catching up on my sleep. That last week was brutal. Hey, join me tonight, because the incredibly brave woman who received the ransom demand and reached out to me to submit it, who went through this past week with me, we met each other, went through it, you name it, is going to be on our show tonight, 8 p.m. Eastern. And she is going to explain to you how he contacted her, how he found her, and what her experience went through, what she went through. Okay, so don't miss 8 p.m. Eastern. You will meet Mindy, our person who received the ransom request. How scary, right? Imagine. Oh, you're door dashing. Okay. Well, catch us on the replay, prayer warrior, and be safe while you're driving. Yes, I know. I'm sorry, Michelle. I couldn't retrieve it in my mind immediately. I couldn't transfer over from BK that quick. Yes, don't miss that live. Kaz, for anyone who missed the live last night, we received a ransom request regarding a ransom demand for Sebastian. It was sent to me. The person who received it sent it to me. I submitted it in. Thank goodness we had At Night with us, because they reacted immediately. Law enforcement never did. Well, let me take that back. They had to force law enforcement's hand, basically, to get them to react to 2 or 3 days in, when we thought someone was waiting with our Sebastian. It was terrifying. We couldn't get At Night finally got them to, respond. So At Night put out something. They are requesting, there was in one word, it said demand, other request, federal intervention, because the kidnapping said they had taken him to Cabo, Mexico, which makes it federal, and it was needed federal attention, which it did not get either. So they also included Summer Wells in that request demand for federal intervention into Summer Wells as well. So be there tonight. We're going to talk about it all again, but you will get to hear. And I'm going to do a better job with the text messages that we received from the guy that she received. Yesterday, it was all put together so quickly because I was waiting to be told when I could come forth with it all. So as soon as I was told, I tried to get everything together in like so quick to be able to bring it to y'all. So tonight I'll have it better a little bit today for you, so you can see things better. She's coming on, Mindy is, and it's going to be a show. And sadly, we really were hoping it was going to bring Sebastian home. We really were. We were hoping, and it didn't. But Mini Panthers, thank you for gifting a membership. Welcome to our family reunions and our family. We're one big family here, whether you're in the Bushes replay, whatever, members, but we have our reunion Saturdays at 1 p.m. Eastern time. So yes, meet us tonight, 8 p.m. Eastern. I will see you all later. And thank you for joining me for this. This was historical. We heard a monster today admit to his crimes. And shockingly enough, he was going to try and, put eyes on 4 other individuals. So he will never see the light of day, right? Prayers up to the families, the victims. We will always remember. Hit that thumbs up, share on your way out. Thank you, Whispering Winds. Maj, you did a great job. Everyone, I appreciate you. Keep keeping on. And until next time, 8 p.m. Eastern tonight, talk soon.